Hey everybody, I'm attorney Jason McGrath. I've been a litigator for approximately 20 years now, and we're going to talk about a litigation issue, namely interrogatories. I have propounded and responded to thousands, probably tens of thousands interrogatories in my day, and I'm going to explain a little bit for those of you who are less familiar with interrogatories. Now, different states have slightly different rules, but the rules are really very similar nationwide. And generally, what one party is doing is that they're sending a list of written questions called interrogatories to another party or multiple parties perhaps at the same time. And the party receiving the interrogatories is supposed to respond, typically within 30 days, by answering the questions in written format. You can also produce records instead if the questions can legitimately be answered by producing records. Sort of a limited scope as far as doing that. Or if you're not going to answer, you're supposed to file an objection or a series of objections explaining why you are objecting to a particular interrogatory, or maybe even the entire set of interrogatories, and stating the basis for your legal or quasi-legal or equitable objection. If you have received, interrogatories in a lawsuit, you certainly need to calendar and schedule to respond to them or take some kind of action. And if you have filed a lawsuit or you're going to litigate a lawsuit as the plaintiff, you of course should be using interrogatories to further assist your case. Now, there's limits on interrogatories. Typically, you can propound 50 to a particular party, and that actually is supposed to include subparts and subparagraphs and things like that. That rule is violated somewhat frequently, but you really shouldn't violate those kinds of rules. And sometimes a judge or even another party will agree to allow you more than 50, but that just really kind of depends. But the point of it basically is that by answering these written questions, which, by the way, the party is supposed to sign and execute, basically swear off on the answers being accurate and complete. And in some circumstances, an attorney is supposed to also sign. It just depends a little bit. But basically, if you're responding to the interrogatories with answers, you are basically asserting that the information is correct and true. And you have to realize that can be used in the lawsuit and, of course, used against you if it can be. Now, on the other side of things, if you're the plaintiff or the party that has propounded interrogatories and you're getting them back, you want to evaluate and see, did they really actually answer the question here or not? Or do I need to go to court and say, hey, judge, they didn't answer this. They need to answer it. This is not sufficient. And of course, those answers can be used later in many instances at trial or at deposition or anything else. So it's really, really important that you carefully consider the interrogatories both on the front end, if you're drafting the interrogatories to be sent to a different party, or if you have received those interrogatories and you need to respond. That's it for now. If you need any help, contact us. We do litigate, particularly in North Carolina, and we have lawyers licensed in multiple states. But give us a shout if you need any help. But otherwise, good luck, and I hope this has been helpful. Thanks.